Faculty members are how intensely they are excited and enthusiastic to listen about this topic. So I'll not take much time because we are eagerly waiting to listen from Professor Dr. Priya Makhavan, who is the main legal team member of the Indian government when they placed this case in International Court of Justice. And we are very happy today that we have got the support from Ministry of Foreign Affairs of Bangladesh government um, to organize these events, because without their support it could not be happen, because this team member, they have come here in the invitation of the Ministry of Foreign Affairs. We have with us Mohammad Farooq Hussain, Director UN, and also another DG, Myanmar side. Mr. Delwar has arrived. He is also within us. So we are again giving a big thank to Ministry of Foreign Affairs to assist us, Center for Peace Studies of South Asian Institute of Policy and Governance, to organize this event. I do welcome Professor Paya Makawan from McGill University. He is basically an academician, also a lawyer. And that's a very interesting mix. And I'm sure that that would be interesting for us also, that as a university, we will be listening from him, both the legal perspective and also the academic perspective of this whole verdict issue. I also thank to Mr. Shohidul Haq, this ex-senior secretary, Minister of Foreign Affairs, and now uh, the senior fellow of South Asian Institute of Policy and Governance, who was also the main instrumental for organizing this event. And he will be basically moderating the session. Before I end my welcome speech, I just give a little bit idea about the modality of today's program. So I will hand it over to Sir Shohidul Haq. He will moderate the whole session after me, and then we'll have probably half an hour to 35 minutes presentation or speech by Professor Dr. Priya Makavan. And then also we'll have, and that would be the most interesting part, we'll be having very interactive session with the question answers from the students and faculty member. And after that, probably we'll also hear from the DG Myanmar of Bangladesh government before we go for the ending, where the chair of the English department, Dr. Ishtiaq, give the closing remarks. And finally, Law will be giving the closing remarks. And I also finally thank Department of Law to being the joint partner of this initiative, and also thanking all the students, faculty members coming here in this very interesting event. By that, I'm handing it over to Mr. Shohidul Haq, Senior Fellow of South Asian Institute of Policy and Governance of North-South University.
Thank you, Professor Tawfiq. My name is Shahidul Haq, as has been mentioned. It is indeed a great honor and pleasure for, I think, all of us at the North-South University to welcome Professor Dr. Payam Akhavan. I said, how do I introduce you? And he said, just say, friend of Bangladesh. And that's what Professor Payam has been. He has been with us now, but what, 20 years? 12 years. He has also been a member of our team, which helped us in the maritime dispute settlement. And he has also genocide case in the ICJ on behalf of OIC and Gambia. We had the privilege of being in Hague and work with him. He is in Bangladesh currently. He'll be going to Cox's Bazar tomorrow to see for himself again how the Rohingyas are faring, and also talk to some of them. But as I started off saying, and I'll conclude by saying that he's a friend of Bangladesh. Please feel free to ask any question. But I also would like to flag that because of his current assignment with the legal team, he would possibly not be able to answer full, but I'm sure he will find a way out, as he does when he teaches students. Sir, you have the floor.
I also just to mention it that this whole event is in Facebook Live and YouTube Live. So I'm sure many of our friends from home and abroad, they are also watching this.
Alaikum salam. It's a great pleasure to be here in Bangladesh. I would like to thank the distinguished Dean, Director, and faculty members of North-South University for giving me this honor, and especially to my dear friend and esteemed colleague, Mr. Shaidul Haq, who to me is one of the outstanding sons of Bangladesh, who has done such great service for his country. And it's a great pleasure to give my first ever public lecture in Bangladesh in his presence. And I wish to acknowledge as well our esteemed representatives from the Foreign Ministry who have kindly arranged this trip for me. And to all of you, students and faculty members, for honoring me with your presence today. 75 years ago, on January 27th, a group of Soviet soldiers who were walking towards the city of Krakow in Nazi-occupied Poland came across a strange semi-destroyed industrial site. They approached the site, and there they saw piles of dead bodies and mountains of ash, and about 7,000 prisoners who looked like walking skeletons. And they were the sole survivors of the 1 million Jews who were killed in what we now know as the Auschwitz concentration camp by the Nazis in pursuit of their genocidal ideology of racial purity. 3 years later, on 9 December 1948, the United Nations General Assembly adopted the first ever human rights treaty known as the Convention on the Prevention and Punishment of the Crime of Genocide. The leaders of the world who adopted that convention in the shadow of the Holocaust and the monstrous atrocities of the Nazis said, never again will we allow these crimes to occur. Sadly, never again has become ever again, as millions and millions of people have fallen prey to the same horrors of genocide. And it's not lost on me that this month you will commemorate the 100th anniversary of the birth of Sheikh Mujibur Rahman Bangabandhu, and at the same time commemorate the 49th anniversary of the War of Liberation that in 1971 brought to the people of this country also the tragedy of this word that we know as genocide. Genocide, of course, as a concept of international law, has a certain definition, which is contained in Article 2 of the 1948 Convention. It is the intentional destruction of a group, but very often we lose the reality of human suffering in these abstractions, because behind every victim there is a name, there is a mother and father, a brother and sister, a whole universe of human relations that is forever destroyed. And as I will explain, when we forget the reality of human suffering, we forget why justice is absolutely important. This in a world where all too often political expedience tells us to sweep everything under the carpet. Let's not forget about suffering and injustice. Let's not worry about the thousands of women and children and men who have been killed and subject to sexual violence, because there is business to be done. There are geopolitical interests. There are other things which are more important than doing justice. And this is what I've learned through 30 years of struggling as an international lawyer, struggling for human rights, that there's always a reason not to do something. And it always takes courage and the willingness to sacrifice one's short-term interests in order to achieve some measure of accountability. And that indeed is the story that has brought us to this historic point, as I will explain, when just over a month ago, the International Court of Justice, in a historic and unprecedented judgment, unanimously ruled that the government of Myanmar is under an obligation to take all possible measures to prevent the commission of further genocidal acts against the Rohingya minority. And I wish to acknowledge to both the government and people of Bangladesh the tremendous sacrifice and humanity which you have demonstrated in receiving the 1 million Rohingya refugees at a time when governments in the Western world are putting migrant children in cages and treating them with such inhumanity. And I think that you also are demonstrating what moral leadership means. Moral leadership is not just about military and economic power, it's about humanity. It is about moral principles. And I would certainly hope that the rest of the international community would give Bangladesh the support that it deserves in dealing with this ongoing humanitarian nightmare. I graduated from law school in 1990, and for me, the idea of international justice was still a distant dream. In 1990, the only example of international justice we had was the Nuremberg Tribunal, which was established in 1945 to prosecute the vanquished Nazi leaders. And for the most part, throughout the Cold War, there was a culture of impunity, that those who committed genocide were never brought to justice. And of course, the War of Liberation in 1971 was exactly one such example, as were the killing fields in Cambodia and the many other examples that one could speak about. And then in that window of opportunity, the Yugoslav War broke out, and the United Nations Security Council, for the first time ever, established an ad hoc jurisdiction using the enforcement powers of the UN Security Council under Chapter 7 of the UN Charter. And the idea of international justice was once again reborn in the historical background of Nuremberg. And I had the privilege of serving as the first legal advisor to the International Criminal Tribunal for the former Yugoslavia. But unlike Nuremberg, where the Allied powers had militarily vanquished the Nazis, where they could simply, with their army of occupation, arrest the perpetrators and put them on trial, the Yugoslav Tribunal was established at a time when the war was still raging, and there was no willingness on the part of the international community to confront the Yugoslav leadership. And in fact, it took at least 16 years to arrest Ratko Mladic, General Ratko Mladic, the butcher of Bosnia, who was, among other things, responsible for ordering the mass execution of some 8,000 Bosnian Muslim men and boys in Srebrenica enclave in the summer of 1995. So I've learned that it may seem naive and idealistic to demand justice, but with patience and determination, it is possible. And we have to remember that as we look today to the tragic plight of the Rohingya and the indifference of the international community to their suffering. The establishment of the Yugoslav Tribunal was followed in 1994 by the establishment of the Rwanda Tribunal, and by 1998, at the Rome Diplomatic Conference, the statute of the International Criminal Court was finally established, some 50 years after the Genocide Convention was adopted. The International Criminal Court, of course, is a very important institution. Bangladesh is among the few countries in Asia which is a state party, which again is another commendable reflection of the commitment of this nation to international law. But the International Criminal Court perhaps has not satisfied the hopes and aspirations that many had for it. It is beset with lack of political support, budget constraints, internal difficulties. But in the case of the Rohingya, the biggest problem is that Myanmar, predictably, is not a state party to the statute of the court, which means that the court has no jurisdiction, because one of the first things we learn in international law is that the consent of courts cannot be presumed. It is based on the consent of states. States must, one way or the other, accept the jurisdiction of international courts. And a big part of my work as an international lawyer is shopping for a jurisdiction, figuring out how is it that we can use international courts and tribunals in order to advance the rule of law and human rights. And of course, one of the questions we have to ask ourselves as well is, even if there is a court with jurisdiction, who is there to enforce the judgment of the court? And as I will explain, one of the significant aspects of this experiment in international justice is to understand the power of legitimacy, that in an interdependent global village, nations must understand that their projection of power, the pursuit of their interest, depends in significant part on their legitimacy. And what greater measure of legitimacy can there be than complying with one's obligations under the 1948 Genocide Convention? Getting back to the case of the ICC, the International Criminal Court, and the ICJ, the International Court of Justice, the main difference is that the ICC is responsible for individual criminal liability, whereas the ICJ addresses questions of state responsibility, the responsibility of governments. And each has an important role to play in imposing accountability. And the Rohingya case is historic, among other reasons, because for the first time, both the ICC and ICJ are engaged. Through some creative lawyering, the idea emerged that while there is no jurisdiction over acts committed wholly within Myanmar, there is jurisdiction in respect of acts which, although they commence in Myanmar, are completed on the territory of Bangladesh, insofar as Bangladesh is a state party and the court has jurisdiction in respect of acts committed on its territory. And just like crimes such as human trafficking, which have an inherent transboundary element, the very definition of the crime presumes movement, for example, of human beings from one jurisdiction to the other. The crime against humanity of deportation also has an inherent transboundary element. The crime is completed when individuals are forcibly displaced, typically based on persecution on racial, religious, and ethnic grounds across a boundary. Based on that notion, the International Criminal Court held in September of 2018 that it has jurisdiction in respect of the crime against humanity of deportation based on the territory of Bangladesh. And I had the honor and privilege at that point in time, when Honorable Mr. Shadow was the Foreign Secretary, to serve as counsel to Bangladesh and to prepare its submissions to the court, which of course were submitted confidentially, but it is very clear that Bangladesh played a central role in ensuring that the court at least could address a slice, just one slice of the many crimes that were committed in Myanmar. So some justice is better than no justice at all. And the investigation in respect of the Rohingya, which has now begun, may very well lead to arrest warrants against suspects. Some of those suspects, according to the United Nations fact-finding mission, which I will address shortly, include 6 senior members of the so-called Tatmadaw, Myanmar's military, which of course has played a central role in the campaign of ethnic cleansing and genocide against the Rohingya. And while Myanmar would not be under a strict obligation to comply with such arrest warrants, it is still a very significant liability for a state to have its senior leadership accused of crimes against humanity by the International Criminal Court. But the ICC left unaddressed the bigger question, if you like the expression, the elephant in the room, was the crime of genocide, which is committed wholly within the territory of Myanmar, where the ICC would have no jurisdiction. So some human rights advocates began to think about how it would be possible to bring a case before the ICJ, because unlike the ICJ does have jurisdiction over the crime of genocide, because Myanmar, when it was still called Burma in 1956, ratified the 1948 Genocide Convention, and Article 9 of that convention confers jurisdiction on the ICJ in respect of disputes over the application and interpretation of the Genocide Convention. Except that the ICJ only has jurisdiction in disputes between states. Only another state could bring a case against Myanmar. And of course, in the realm of international relations, the complexities of politics are such that unless a state has a very compelling interest that is not outweighed by a whole set of other considerations, it is really not willing to bring such a case, especially where it is not directly injured. The first time that the Genocide Convention was invoked before the ICJ was in 1993 by Bosnia against Serbia. And of course, Bosnia had a direct interest in holding Serbia accountable for crimes that were committed on its territory. But what happened subsequently was quite remarkable. At a meeting of the Organization of Islamic Cooperation, comprised of 57 member states, covering the Islamic world, all the way from Indonesia across the Middle East to Western Africa, that sort of significant cross-section of humanity, one of the members of the delegation of a small West African nation called the Gambia, a former colleague of mine, Abu Bakr Tambadou, the Minister of Justice of the Gambia, who was previously a prosecutor at the International Criminal Tribunal for Rwanda, came to Bangladesh. He went to Kutupalong. He saw the sea of human misery and suffering and was so moved that, with the support of the 57 members of the OIC who had called for accountability in respect of the Rohingya genocide, he decided that it would be the government of the Gambia that would bring this case in its own right, but also on behalf of the 57 members of the OIC. And that is how we ended up where we are today. In October of 2019, we were informed, after many months of speculation and uncertainty as to whether this case would ever happen, that the Gambia had decided to bring this case against Myanmar under Article 9 of the Genocide Convention. That itself raises a very interesting issue. What business does the Gambia have to bring a case against a country that is 10,000 kilometers away from it, in the name of people with whom it shares very little, perhaps, except a common Islamic faith? And this is a perfect example of what it means to be a good global citizen. It is an example of what it means to express solidarity with victims of genocide and to transcend all that divides us, to stand for our shared humanity. And I think it's extremely powerful that it was a small African nation of 2 million people halfway across the world that stood up and exercised moral leadership to bring this case forward. But it's especially significant that it is with the support of all 57 members of the OIC. It is unprecedented to have the OIC member states invested so significantly in what is in effect human rights litigation before the World Court. When we were given finally the green light, of course, we scrambled to draft an application as quickly as we could. And within 1 month, on the 11th of November, we filed the application before the International Court of Justice in The Hague, which commenced the proceedings against Myanmar. One of the issues, of course, is the urgency of this matter. We're not dealing with what happened in 1971 or what happened in 1945 or what have you. We're dealing with an ongoing tragedy which is still unfolding in Myanmar, where the Rohingya still face systematic persecution and violence. So our first thought was that beyond the judgment on the merits, which looks at the question of Myanmar's responsibility for the crime of genocide, that we must do what we can to protect the 600,000 Rohingya who are still in Myanmar. Of course, Bangladesh knows more than anyone the reality of so-called ethnic cleansing and genocide. You have 1 million Rohingya on your territory, severely traumatized by the horrors that they faced. But there are still 600,000 other Rohingya. And the first order of priority is to ensure that they do not fall victim to the same crimes and that 600,000 more refugees don't end up here telling the horrible stories of what they have suffered. So we requested, upon filing our application with the court, what are called provisional measures. Provisional measures are, in effect, protective measures, where we ask the court on an urgent basis, pending a final judgment on the merits, to prevent irreparable harm by ordering Myanmar to take all necessary steps to prevent acts of genocide, because one of the obligations under the convention in Article 1 is the obligation to prevent and to punish. And we can agree that it's much better to prevent than it is to punish. We always say in my line of work that the measure of success is what doesn't happen, what does not become headline news, what does not end up on the agenda of the UN Security Council. And we realize that genocide is not like an earthquake or tsunami. It's not a God-given disaster. It is a man-made disaster. It is a political choice. Governments choose to incite hatred and violence as a means of exercising power. So it's our job to use international courts and tribunals, the institutions of justice, in order to exact a cost, in order to deter those crimes by sending the message that you cannot enjoy impunity, that you cannot just murder tens of thousands of people and subject them to sexual violence and pretend as if nothing has happened. So within 1 month, we ended up before the court on the 10th of December 2019, which coincided with United Nations Human Rights Day, and exactly 71 years and 1 day after the adoption of the Genocide Convention on 9 December 1948. And as I had the honor to stand up before the court to introduce the pleadings on behalf of the legal team with my outstanding and dedicated colleagues, I once again reminded the court of the words which were uttered 71 years earlier before the UN General Assembly: never again. Never again. And the emphasis in that hearing was, well, we cannot do much for those who have already been killed, those who have been subject to horrific sexual violence, whose lives have forever been destroyed, but we can do what we can to try and save the 600,000 who are still in Myanmar. It was remarkable when we learned that Myanmar would not only appear before the court, but that it would be represented by the state counselor, Aung San Suu Kyi, and that ensured that this case received unparalleled attention before the international community. A small anecdote just before speaking about the hearing and the judgment and then wrapping up my presentation. Just a few days before the hearing, and you can imagine the lawyers scrambling to put together the evidence and their legal arguments, and arguing this case before the court, of course, was not just any old case. It was a case of great moral, historical significance. So we all wanted to do our very best on behalf, not just of the Gambia, of course, and not on behalf of the OIC, but especially on behalf of the victims. And I had, in June of 2018, at the kind invitation of Mr. Hook, made my first visit to Kutupalong camp in Cox's Bazar, where I'd heard firsthand the heartbreaking stories of the survivors, who then look at us from the outside world and said, what can you do to help us? How can we achieve justice? And it's very humbling to realize that one can do so little. But finally, against overwhelming odds, we were standing there in The Hague at the International Court of Justice. So the thought occurred to us that we must try and bring some of our Rohingya brothers and sisters to The Hague for this hearing. And through the help of the government of Bangladesh, the government of Canada, the government of the Netherlands, we found three remarkable individuals by the name of Yusuf, Hamida, and Hasina, who are refugee representatives in Kutupalong, who themselves have witnessed unbearable suffering and horrors. And these three wonderful souls, who had never left their country except to be pushed across the border into Bangladesh, who had never been in an aircraft, and their first ever flight was on Emirates, not a bad way to start your first experience at an airplane, managed to get their travel documents and to get on an airplane for the first time ever and travel halfway across the world to The Hague, and to come to this very impressive building called the Peace Palace, which is intimidating even for those of us who are very well-traveled and cosmopolitan, and to sit in the same room as Aung San Suu Kyi, where she had to sit for hours and listen to the lawyers for the Gambia detail all the horrific crimes that have been committed against the Rohingya. And their presence in that courtroom, I think, completely transformed, once again, the understanding of justice. Because justice is not an abstraction. Justice is about that woman whose 2-year-old child was burnt alive by the Tatmadaw. And I could go on and speak about the many horrible stories of inhumanity which all of us are unfortunately too familiar with. When we pled our case before the court, there was a remarkable sense of solidarity. In the courtroom were seated, other than the Gambia, a delegation from Bangladesh, including our dear friend, Mr. Shaheholder Hope, delegation from the government of Canada, who had appointed a special envoy in respect of the situation of the Rohingya, the ambassador of Saudi Arabia, the ambassador of the United Arab Emirates, the ambassador of Senegal. The whole world was there. And it was a remarkable moment, as I explained, where the OIC committed itself to respect for human rights, committed itself to global justice. Now, after the hearing, of course, we were all quite exhausted, and you never know what to expect with a court judgment. One can only speculate, but there are no guarantees. And of course, the International Court of Justice is not necessarily a human rights court. It usually deals with boundary disputes, and you referred to the Bay of Bengal arbitration, and these are the kind of things that international lawyers very do. Two governments have a dispute with each other. There's a dispute over sovereign immunity and what have you. But here was a case which really was on behalf of humanity. The Gambia was the vehicle, but the case was not about the Gambia. It was about a common interest that all nations have in suppressing the crime of genocide. So when we heard in January 23rd, and I sat in the courtroom as the judgment was being read, and you know the president reads the judgment very slowly, very deliberately, it takes about an hour, and your heart is in your throat because not about so much about your professional ego, but you think about those people sitting back in Kutupalong. And the government of Bangladesh took the measure of ensuring that there was some means for the people in the camp to have access to the reading of the judgment. And when the president said unanimously, I think all of us were completely delighted at this result because it was not what we anticipated. And I say this because there are 15 judges on the International Court of Justice, and there are 2 judges ad hoc appointed by each party. The Gambia appointed Navi Pillay of South Africa, former UN High Commissioner for Human Rights, a former judge on the Rwanda Tribunal, which delivered the historic Akayesu judgment, first judgment on genocide by a UN tribunal. Myanmar appointed as his judge ad hoc Professor Klaus Kress, a highly respected academic from Germany, and it was unanimous. Even the judge appointed by Myanmar voted in our favor. So to wrap up my comments, we are now in the process of preparing the written submission of the Gambia on the merits of the case, which of course is a far more complex and challenging phase of the proceeding. We will have to submit it to the court just 6 short months after the date of the judgment, which is January 23rd. So by July 23rd, between now and July 23rd, my colleagues and I will not be getting much sleep. And that's part of the reason why I'm here in Bangladesh to gather evidence and to try to prepare this pleading. And I must once again express my sincere gratitude to the Foreign Ministry and to the government for all the courtesy that it has extended to us as we prepare this case. There is still a long road ahead, but in the meanwhile, I think we have taken a significant step forward on the path of justice, although there is still a long way to go. And I will end by perhaps recalling one of the poems of the great Rabindranath Tagore, who said that the bird of faith feels the light even in the darkness before dawn. And I think we need to understand how important it is to speak truth to power and never underestimate the importance of the choices that we make in a world where it is too easy to be cynical and simply to give up and think there's nothing to be done. So I thank you very much for your patience. Khuda Hafiz. Thank you.
Thank you, Professor Paya Makhavan, for your very lucid description of a very complex, complicated process. The floor is open. Before you seek clarification or ask questions, please briefly introduce yourself. And I would urge that if you could concentrate your question, that will help all of us to have as many as participants as possible in the proceedings. So, floor is open.
Good afternoon, Mr. Paya Makhavan, for excellent speech and sharing your experience in ICJ. So I have some questions about that is the prospect of these litigations in ICJ with regard to the genocide, whether this atrocity of the Myanmar can be considered in true sense as per the Article 2 of the Convention, genocide. For example, in Bosnia-Herzegovina, the ECJ has ruled that as far as I've understood, that ECJ has ruled that that is cleansing, ethnic cleansing. So this is the term mostly used in this case like this, ethnic cleansing. So ethnic cleansing is not a part of the definition of genocide as far as I understand from Article 2. But the difference between these two, I'm just, before making the question, I have to just give the background, that's right. So there's two things, different, ethnic cleansing and genocide. So as far as the judgment is concerned in Bosnia, so it was actually, no judgment was given, no adequate remedy was given, because there has to be some expulsion, intention to destroy the whole or partly community is required, not the intention to expel or intention of dissolution of this community. So here the same thing also is going on. So Myanmar, the Aung San Suu Kyi may not have intention to destruct or kill the part of the community. Rather, their main intention was to expel them from the region of Myanmar to ensure the that is homogeneous character of the communities, right? So if the same argument comes here in Myanmar case, then we don't see the adequate prospect of success for Gambia. So what is your view in this matter?
Thank you, Professor. It's a very good and sophisticated and advanced question, which I'm pleased to reflect on. As you described it, ethnic cleansing and genocide are not the same thing. Well, ethnic cleansing is not a legal term; it's a descriptive term. There's no crime of ethnic cleansing. There is a crime against humanity. There's a category known as crimes against humanity, which is any widespread or systematic attack against the civilian population. It includes persecution on racial, religious, ethnic grounds. And then there's the crime of genocide, which, as you explained, has a very specific definition under Article 2 of the Convention. So we are well aware of that. And if you see the application that we've submitted to the court, which is available on the ICJ website, one of the very first paragraphs says the Gambia is well aware of the difference between persecution, discrimination, deportation, and the crime of genocide. Ethnic cleansing, which emerged in the context of Bosnia, where I began my first years with the United Nations, speaks in general about violent demographic change, where you want to eliminate a certain ethnic group from a given territory. That can be achieved in many ways. It can be achieved through terrorizing people to leave, which is a kind of deportation, or it can be achieved through extermination, which is genocidal. And it is our view, as we submitted before the court, that the acts, at least some of the acts perpetrated by the Tatmadaw against the Rohingya in Rakhine State are clearly with genocidal intention. And in proposing that, we are supported by the United Nations fact-finding mission that between March 2017 and September of 2019, almost an over 24-month period, interviewed 1,100 victims, some 250 other witnesses, and came to the conclusion, among 3 distinguished jurists, that these were in fact genocidal acts. The UN Special Rapporteur on Human Rights in Myanmar, Yang He Lee, has come to the same conclusion. The United Nations Special Advisor on Prevention of Genocide has also come to the same conclusions. So there are many studies, very serious in-depth studies, which have already come to that conclusion. But just to give one quick example, one of the typical patterns among the 392 Rohingya villages which have been destroyed by the Tatmadaw is that the Tatmadaw will enter a village and they will go door to door and kill every man, woman, and child that they will find. The killing of children in particular is one of the classical signs of genocidal intention. You're not just killing men of military age, you're basically killing everyone that you can. And one other issue is, beyond killing, sexual violence is equally a genocidal act. This is something which the Akayesu judgment at the Rwanda Tribunal told us in 1998. So in addition to killing, there has been extensive evidence of systematic use of rape against Rohingya women, but also men. So it's our view that these are not just ethnic cleansing in the sense of we want to get rid of the Rohingya, but it's an actual intention to physically destroy them. And a significant proportion, if not practically all of those that are refugees here, managed to escape. Their lives were not necessarily spared. They simply managed to escape before the Tatmadaw would get their hands on them. So that's our view on the merits.
Thank you.
I'm Rizwanul Islam, a faculty member here at the Law Department. So thank you very much for your excellent presentation. If I may just ask your views on one of the remedies sought by Myanmar, the Gambians, that the Rohingyas are Myanmar citizens. So citizenship, as we basically understand, is predominantly a national law concern. So if you could share your thoughts on that to what extent ICJ is likely to dwell on that question of nationality. And secondly, if I may ask, based on the history of lack of use of Article 94, Sub-Article 2 of the UN Charter, even assuming that there are some mandatory directives given by the ICJ in this case, do we really have a hope that some concrete actions would be taken by the Myanmar authorities? Because signs are already there that Myanmar is not too perturbed by the prospect of a potential adverse judgment. Thank you very much.
Thank you. Those are two very good questions. I will answer them briefly. The first one goes to what I said about the importance of legitimacy. You're correct that there is not a kind of global police force that's going to go and execute the judgments of the court, although the UN Security Council is notified of a provisional measures order, which was transmitted to the council. And sadly, in the world of politics, power realities too often predominate rather than considerations of justice and morality. But still, we have to do what we can. And I think the fact that Myanmar has chosen to vigorously defend these accusations is a sign that it matters. It matters to them. And if you want to be a player on the world stage, it's a huge liability to be a state that has been held responsible for the crime of genocide. So I think we shouldn't underestimate, although we shouldn't overestimate it either, but we shouldn't underestimate the importance of this judgment, especially because the court took the unprecedented step of requiring periodic reports from Myanmar, which it has never done before in any other judgment. So at the very least, Myanmar knows that the world is watching now, that the next time they think about going into a village, committing those atrocities, we're going to be right back before the court, and all of this will have consequences on their international standing. Your question about nationality, citizenship is a very good one. The case before the court is limited to the crime of genocide. That goes to the nature of jurisdiction. The court doesn't have general jurisdiction in respect of Myanmar, which would have required Myanmar to make a declaration under Article 36, Paragraph 2 of the statute of the court. So we are limited to the crime of genocide, which goes back to the question you asked, sir, that there are a lot of crimes which are not included. And that's some of the things we have to also explain to our Rohingya friends, that we cannot deal with every single one of the issues that you're dealing with. However, the court did take note of the 1982 citizenship law, because it's one of the factors, one of the indicia indicating a genocidal intention. The mere existence of the 1982 citizenship law is not obviously a genocidal act, but the fact that you systematically strip a group of nationality based solely on race. In fact, it is race, because the 1982 citizenship law indicates that only recognized national races will be given Myanmar nationality, and the Rohingya are not one of the recognized races. Well, that is racism. It's literally racism, because you're excluding a group because they don't belong to a national race. Well, that's not the way international law works. So that is an indication of the pattern of conduct which ultimately escalates into genocidal violence. At first, you strip people of citizenship, then you deny them civil rights, you deny them right to education, you deny them property rights, you incite hatred against them, and then at the final end of the spectrum, you have the campaign of extermination to actually physically destroy that group. I will just say one small thing, just as a kind of aside, which is that you're right that citizenship laws are governed by national law, but there are also obligations under international law. One of those obligations is not to render people stateless. Another obligation is not to discriminate. So a government which turns around and says, well, we will give citizenship to everyone except people who have a certain color of skin or people who have a certain religion, well, that government is acting manifestly in violation of its obligations under international human rights law. So it is not the case that Myanmar, or for that fact, any other government, has a right to simply strip people of citizenship. And I think I will stop there, but we know what the significance of that is for what is happening in this region at the moment.
Thank you. Yeah. My heartiest appreciation for the very lucid way of presentation of very difficult legal issues that you have presented, made us understand to that. When this International Court of Justice pronounced these provisional measures, there was a lot of euphoria, a lot of optimism also was raised, but at the same time some disappointment was also there, and the common observers like us, because the Myanmar government has committed a crime, and we are in Bangladesh, we are bearing the brunt of that, because the people who have come here, we are suffering from it. The provisional measures talk of prevention, as you said also rightly, that prevention is also, because it's very important that it doesn't happen again. But what would happen about the past, the crime they have committed in the past? I mean, the provisional measures didn't talk about any kind of redressal or what can be done, justice to the already uprooted people or forced people out of their homeland. So, I mean, if ICJ wanted, I'm just asking this question, if they wanted to do something about the redressal aspect, could they do that, or if they were they were bound by some law, they could not talk about past, they could only have to talk about the future? Thank you.
Thank you, Honorable Dean. It's a very good question, and that is the difference between a request for provisional measures and a judgment on the merits. So in effect, the reason why we could get before the court within 1 month and then get a judgment 1 month after that, which is lightning speed, because the wheels of justice turn slowly, was because the provisional measures is only for urgent situations where irreparable harm could occur. So it's impossible within 1 month to have a judgment on the merits. And that's why the mandate or the jurisdiction of the court in this regard is limited to future acts and not acts which have already occurred, which will be part of the merits. And I anticipate that within maybe 2 or 3 years, we will have that judgment. And I can assure you that once again, the application of the Gambia is available on the website of the International Court of Justice. And among the remedies which it seeks from the court is obviously a declaration that Myanmar has failed in its obligation to prevent and punish the crime of genocide, that it must cease and desist from such acts, and so on and so forth. But one aspect which is of particular interest to Bangladesh is a request for reparations, including the right to a safe and dignified return. Now, whether the court grants that or not, I cannot tell you. I certainly hope they do. But in principle, an aspect of reparations is a return to the what we call status quo ante, to basically restore and make whole the victim, which in this case, we argue, means to bring them back to where they were before the commission of the genocide.
Good. Could we go back to the students, please, and then we'll come. Yes. Any questions from the back? The students? Yep. Okay. Please go ahead.
Good afternoon, sir. I'm Humaira from the Department of Law. So you are already repeat the thing that why actually Gambia took stand for Rohingyas. Yeah. Actually, what concerned Gambia to take stand for Rohingyas before ICJ? Can you please repeat it again?
It's a very good question. The Gambia is a member of the Organization of Islamic Cooperation, which has 57 member states. And in the context of the OIC's decision that something must be done to bring justice to the Rohingya, the Gambia accepted to bring a case before the International Court of Justice. And I should add that the Gambia, since 2016, has had a democratic spring, where after 20 years of a very terrible tyrannical regime, you have a young democratic leadership which is very committed to international law and human rights. And the Minister of Justice, as I explained, Abu Bakr Tambadou in particular, is a very idealistic, principled man who was very moved when he came to Bangladesh and witnessed the suffering in the camps. And he's a former colleague of mine at the United Nations Rwanda Tribunal. So he understood very well the importance of international law. So that is what has happened.
Good. Could we come to the front?
Good afternoon, everyone. I'm Sarah Toby from Law Department, a student of Law Department. Sir, as many of us know that the panel of the Honorable 17 judges of ICJ has ordered Myanmar to prevent genocide and anything which causes physical or mental harm. And it was also said that Myanmar has to report within 4 months. So my question is, at present, is there any team to monitor their ruling system, or can ICJ send any team to monitoring their ruling system? Thank you.
A good question, and the answer is unfortunately not. There is a great sort of sacrosanct principle of state sovereignty, and the court in particular, I don't think would go so far as to say that a government is under an obligation to allow outsiders to come and conduct investigations. So there's a self-reporting requirement where Myanmar must submit a report to the court, and of course the Gambia has an opportunity to respond to that report. And fortunately in today's world it's difficult to keep things a secret. And it's remarkable, for example, how much you can learn from satellite photography. If a village is burning, you can see it from a satellite. If people flee and come to the refugee camp here, there will be aid workers, Bangladeshi officials and others, and journalists and NGO workers who will relay that story to the global media. So the one thing that is good about the current information revolution is that once upon a time, if some people were massacred in a distant village, the world may have never heard, or it may have been years before they've heard. Now we know in a matter of hours what has happened.
Shall we take that 2-3 questions? Okay.
So what we do now, because of the time constraints, we'll take 2-3 questions and then
And that's why supplementary. Can I ask? Okay. So regarding these, all about evidence, the problem is international law is fully mired with politics, right? So there is a very important issue of international law applications. So we have seen that there is no implications of the ruling. So in this scenario, that the question of evidence, the direct and fastened evidence, in absence of which it might be difficult to prove the case, even if the atrocity occurred. Same as Bosnia, a lot of things occurred, but problem was they faced difficulty in producing first-hand evidence. The same situation might also be apparent in here. Bangladesh is the only country who has a first-hand knowledge and experience about the atrocity. Bangladesh is not a party, whereas the Gambia having no connection with the evidence. So do you think that it's a challenge for the Gambia to establish the case when it will go on merit?
can we take another question from the back?
Okay, sure. Thank you. My question is an extension of her question, actually. It's under Article 1994 of the UN Charter, all member countries must abide by ICJ decisions
in cases to which they are a party. And in the event of non-compliance, that's my question. In the event of non-compliance, quote unquote, the UN Security Council may decide upon, quote unquote, decide upon measures to be taken to give effect to the judgment. So what does that mean? If ICJ can't do anything, considering or taking into consideration national sovereignty or other things, so what's the jurisdiction there, at least to some extent, if there is any? Thank you.
Yes, Article 94 is significant, and the point being that the Security Council is a political body. It's not a judicial body. There are 5 permanent members, each of which has a veto power, and we know what that means. That unfortunately, unless nations have a unified and principled approach towards these issues, they will each pursue their narrow interests, and that is the enemy of justice. That's why we have a world with so many evils, because people act in the name of political expedience rather than truth and justice. So it's a struggle to get the international community to take seriously the judicial process, because the judicial process is self-contained. Its political consequences are something that we do not control as lawyers. We are there to prove our case before the court, which is why I think the role of the international community is so important. And the international community is not just government officials and diplomats, it's also journalists, academics, it is activists, civil society, and the many voices that, just as in the days of former Yugoslavia, there would have been no Yugoslav tribunal were it not for the global outcry and demands for justice. There would have been nothing. So that's why I think this is just the beginning of our journey towards justice. And we need to ensure that all the stakeholders are engaged and take seriously the judgment of the court and the process, and send a message to Myanmar that they will expect compliance with its obligations. And I will just end by saying that in today's world, it goes back to what I said about legitimacy. Legitimacy is very important. We shouldn't underestimate it. You want to attract tourists, you want to attract foreign investment, you want to grow your economy and develop a certain prestige and status in the international community. It becomes very difficult if you are sitting under a shadow of accusation, let alone a judgment on genocide. And the question of evidence, which is a very good, very complex one. In a case like this, obviously one does not rely on a single source of evidence. There will be multiple sources of evidence. And what I can say is that although Bangladesh is not a direct party in this proceeding, the government of Bangladesh has been very forthcoming in, well, for one thing, allowing me to be here, and looking at the evidence which is first and foremost available here, because there is no access to Myanmar. So while Bangladesh is not directly a party, perhaps for understandable reasons, I think it is clear that it plays a central role. And in fact, at the hearings, you will see that the name of Bangladesh came up again and again and again in the pleadings, both on the part of the Gambia and Myanmar, and in some of the observations of the judges. So one way or the other, Bangladesh is involved.
Thank you very much. I am Brigadier General Dr. Sakhaut Hussain, Senior Fellow of SIPG. I don't have a question on the aspect of the law, but as you said, and as you know, that ICJ in fact does not even have observer or observing capacity what is happening in Rakhine. There are still internal displaced person concentration camp, if you call it, those who have not been dismantled. Just a few days back, as I could read from the various sources, there was a fight between the Arakan army and Tatmadaw, and there were human shield made. The Rohingyas were made human shield. 5 of them were killed in that fight. So it seems that the Myanmar, or the authorities in Rakhine, is continuing in a different technique to scare the rest of the Rohingyas either to leave or to disappear. So if this is happening, what's in Rakhine, do you think that Myanmar has really taken the verdict of the ICJ, as you said, with that spirit? They remain in isolation for 50 years. And I think they don't mind even remaining in isolation for another 50 years and they can continue. Thank you very much.
I think I realized that he's a right-hander. I always going to let's go to the left.
Let's go to the left. Yes. I'll come on the corner.
Thank you, sir. I have a question. I'm picking up one comment from Professor Pam Akapan that Gambia is somewhat. I'm Kausar Ahmed. I'm a lawyer. So Gambia is 10,000 kilometers away from Myanmar, and actually, the action of Myanmar, Gambia was not physically directly affected by the action of Myanmar vis-a-vis the Rohingyas. And as I have also gone through the application instituting proceedings, my perception is Gambia is relying on rather a thin theory of dispute. So in this backdrop, my question is, what makes you think that the case brought by Gambia is not an actio popularis?
First, the question that you asked, sir, about Myanmar and its past of isolation. And to be very frank, I'm not a Myanmar expert. I'm just an international lawyer, and I bring cases before the courts, and I cannot always predict accurately what consequences they will have. To put it bluntly, I think some justice is better than no justice at all. At the very least, we can say we tried. And I think that the world is a slightly better place with this case than without it. And that's not saying much, because the immensity of the injustice is so great that we have to be very humble and understand that whatever we do is very small in comparison with the immensity of the suffering. But even governments that may be authoritarian, isolationist, they have elites. Those elites have business interests, they have bank accounts, they have investments, and we live in an interdependent world. So isolationism is a matter of degree. Myanmar is not North Korea, and it is actually, I think, quite susceptible to a lot of of the international connections and relations that it has and wishes to have. And as I said, the fact that Aung San Suu Kyi came and defended Myanmar at The Hague is actually a very good sign that this matters, that is not something that can simply be ignored. But we have to wait and see how it unfolds. And in fact, how it unfolds is not so much in the hands of the lawyers that prosecute the case, but in the hands of the international community and what weight they will attach to that judgment. And to the question of the gentleman there, the question of actio popularis, or sort of altruistic litigation, simply means that the Gambia is not what we call in international law a directly injured state. Unlike, for example, Bosnia bringing a case against Serbia, in the context where there are neighboring states, and Serbia was held responsible for the failure to prevent the Srebrenica genocide on the territory of Bosnia. So in that sense, it's actio popularis, because it is in performance of what we call obligations erga omnes, obligations owed to the international community as a whole. And I suppose politically and culturally, it's very fascinating. Why is it that a state would stand up for the rights of others halfway across the world? And in a sense, that's the kind of world that we want, isn't it? We want a world where everybody cares about what happens halfway across the world. And I'm a Persian, so I have to share a poem from Saadi, which is on a beautiful Persian carpet in the UN General Assembly Hall, which says, all people are the limbs of one body. And this is the world that we live in. The reality of interdependence means that what happens halfway across the world has an effect in the other end of the world. And that's what I think a lot of cynical political leaders don't understand. They think they're being realistic because principles are for stupid people that are naive. But no, principles are also about the realities of interdependence. If we create a world in which there is no justice, that you can commit mass crimes with impunity, in the end, we're all going to suffer. And that's why we need to change the discourse. This isn't just about human rights. It's also about security. It's about development. It's about so many other things.
Thank you. I'm trying to go back to the students. Yes, please.
Assalamu alaikum. This is Sanjana from Northsouth University Department of Law, and I'm pursuing my LLM over here right now. So, sir, my concern is you have mentioned that the ICJ verdict is only for the future situations or to prevent the genocides which are going to be held. To prevent them, the ICJ has come to this verdict. But, sir, the thing is not only confined in genocide. It's also been like people are compelled to leave their state, and people are coming to India and Bangladesh as well. So why not ICJ or the Gambia has taken any kind of statement regarding like keeping their people in Myanmar's own state or territory? Because it is also a current situation. People are fleeing from their state every day. So this is also a future concern and a present concern as well. So could you please suggest any words on it?
Thank you. Shall we take another question? Yes, please. Ajwa.
Hello, I'm Khalid Islam. I'm an alumni from English department. There's a part of the lecture I didn't understand in that Bangladesh has both jurisdiction for the ICC and ICJ. And Myanmar, they did not have ICC jurisdiction, but they did have ICJ because they signed some the documents. So there was you mentioned a lawyer who came up with an idea that Myanmar, the ICC would have jurisdiction over Myanmar. Could you please repeat? I did not understand.
Let's take another question and then, yes, please.
Hello, this is Kazimur Faisal. I'm teaching international law at American National University. So it's always a pleasure to listen from the international lawyer and the academic at the same time. So my question, the two questions from me, and first is about the evidence, standard of evidence in this case, because genocide is a crime and it should be proved beyond reasonable doubt. But the fact-finding mission, it collected and decided everything on the basis of reasonable basis, which is very far low from that beyond reasonable doubt. So how you are going to meet this challenge? Because during the oral hearing, the lawyers from Myanmar, they raised this question on the point of this point, and especially paragraph 4114 of the first full report. And I wasn't convinced by the response by Philip Sands. He said that, okay, paragraph 190 has been followed, but how much? So I wasn't convinced. So how we're going to meet this challenge within the 5 months you have to submit. And the second question is about the use of the term NIAC, non-international armed conflict, as the defense of this genocide by the Aung San Suu Kyi and the lawyers. I'm convinced that they have taken the reference from the fact-finding mission report, and I'm also not very convinced as a student of international humanitarian law that all the requirements of NIAC has been met. And I would like to refer the report of International Commission of Juries. They are not also very much satisfied with the standard they used. So are you going to use that defense of the defense during your submission? Thank you.
Thank you.
Thank you for these three questions. I will begin with the last one first. And yes, your point on non-international armed conflict is a good one. The Genocide Convention states very clearly genocide, whether committed in war or peace. So the armed conflict is, in a sense, irrelevant insofar as armed conflict has its own applicable rules. But we're not dealing here with disproportionate attacks and indiscriminate attacks. We're dealing with deliberate, targeted killing and rape of civilians with the intention to physically destroy them. So I think that the whole counterinsurgency argument is quite disingenuous, because there's a difference between armed conflict where, let's say, Tatmadaw will try to defeat ARSA forces, which has nothing to do with going into a village and killing women and children and raping people. So I think it's quite disingenuous and has no credibility. And we recognize very clearly that, yes, there is an armed conflict with ARSA, but that has nothing to do with the policy of physical destruction of an entire ethnic group. The question of evidence is a complex one, and I will have to be very brief here. But the fact-finding mission actually came to the conclusion that, based on overwhelming evidence, 1,100 witness statements, 250 statements by other stakeholders, satellite imagery, a whole lot of evidence gathered over more than 24 months, that it could not arrive at any other conclusion than that these acts were committed with genocidal intention. So that is quite a compelling standard, irrespective of what the standard of proof is before the court. And I think counsel for Myanmar was trying to confuse the standard of proof on the merits with the standard of proof at the provisional measures phase, which is simply a standard of plausibility. And it's interesting that even the judge ad hoc of Myanmar, Klaus Kress, recognized that. He himself rejected Myanmar's argument, saying that the argument which was made by counsel for Myanmar, that because genocide is such a serious crime, there must be a more exacting standard of proof, and the court should more reluctantly order provisional measures. He said, no, quite the opposite. Because genocide is such a serious crime, the court should be safe rather than sorry. The question that the gentleman asked, I realize these are sort of difficult to understand outside of the context of our profession as international lawyers. The International Criminal Court only has jurisdiction in respect of crimes committed on the territory of those states that have signed its statute, that have become party. Myanmar is not a party. Bangladesh is. So crimes that are committed on the territory of Myanmar fall outside the jurisdiction of the ICC. But a crime which is at least partially committed on the territory of Bangladesh falls under the court statute. And the crime of deportation, unlike a crime, let's say, like killing, if someone is killed on the territory of Myanmar, the crime is committed entirely on the territory of Myanmar. But deportation is completed upon being forcibly displaced across an international boundary. So that is a crime that occurs here. And what is very significant, and I cannot speak about the content of Bangladesh's submission, which remains confidential, but one interesting aspect of the judgment of the court is that there is also a crime against humanity now of denial of the right of return, which means that even if people were displaced as a result of war, which is not a crime, civilians may flee, denial of the right to return to their own country is an independent crime, because this is now the real issue. And finally, the question asked by the lady there, as I explained, the jurisdiction of the court is limited to the crime of genocide, which is a very specific crime. So there are many, many other acts of displacement, for example, which we cannot properly bring before the court simply because the court doesn't have jurisdiction. So that's the problem, that our hands are tied and limited to the crime of genocide. But of course, the crime of genocide is the most important crime. So even if we cannot catch all of these other terrible acts, at least we can capture what is the most serious.
Thank you very much. I think we're coming to the end. At this stage, may I request Director General Delwar of the Myanmar Cell to say a few words on behalf of the government.
Thank you, sir. Actually, I am not here as a representative of ministry or government. But since I work with the Ministry of Foreign Affairs, I may share some thoughts with you. Actually, it is my honor and pleasure to be here, to be among you and take part in this valuable discussion on legal aspects. Actually, I came here to learn something with the expectation of learning something from an international lawyer, and I definitely learned a lot. And actually, I noticed there are a lot of questions on why Gambia, why not others. Actually, it is, as the lawyer explained, it is an international obligation. If it were not Gambia, it would have been somebody else. But I want to make it very sure that Bangladesh is very much involved in it from the very beginning as a responsible and responsive member, and also as a very active member of OIC and international community. And most probably we will remain engaged with this initiative in different fora till then. And we also feel that the court will come up with final judgment that may help these people find a better future in their homeland. So I would like to stop here. Thank you very much.
Good. Thank you. Before I request our distinguished chair of Law Department to conclude, may I request Professor Tawfiq to say a few words and do some rituals.
Okay, thank you very much. And again, I want to thank again our distinguished guests and also the Foreign Ministry officials who have helped us to organize this event, and especially the Center for Peace Studies that now we have established at North South University under South Asian Institute of Policy and Governance. We are delighted that we could organize this event, and this is a continuation of our endeavor that we have been doing for last 1 year in different related research and kind of a publications we are doing on Rohingya issue. Last July, we organized a very big international conference, and that was followed by lots of different publications like policy briefs that we produced for the ministry and the other government officials. And also then we carried out, now we are doing a series of research on Rohingya issue with the help of our different partner universities and development partners in terms of thematic areas related with Rohingya and health, Rohingya and education and all these things. So we would be very happy in future that this legal team, that whatever they are doing, and as the academic institutions, we will be very interested to follow and also be part of these things with also collaboration with the Department of Law. Because we have a very young, vibrant, and dynamic law department, and you see this. Most of the students here are the law students who are excited to be part of this interaction session. So before I end up my discussion, we have some small token of appreciation, flower bouquet for two of our guests. One is our today's speaker and also the DG. So can I request to bring the flower bouquet and request our senior fellow of SIPG to hand it over to Professor Akavan first, and also law chair, if you can go there, please. Can we have a big round of applause here? And another fellow and bouquet from our ex-foreign secretary to the DG. Okay, so to the DG Myanmar, Minister of Foreign Affairs. Again, thank you very much.
Thank you. Before I give floor to Dr. Ishtiaq, I just want to flag two things. One is, especially for my young colleagues sitting at the back, it's a fascinating time to live, especially in Bangladesh, for students to study the Rohingya as a forced migration case, not only in terms of its humanitarian aspect, but also in terms of how the international law is evolving and setting new precedents. And also geopolitically, it's a fascinating area. So I think some of you would be benefited by being involved in some of the discussions which will help you in your future job and career. With this, may I request Dr. Ishtiaq Ahmed, who is a barrister at law and JSD, currently chair of the Law Department of North-South University. Please thank and conclude.
Thank you very much. So it has been a wonderful experience, no doubt, that we have learned a lot of things about international law and ICJ. And the beneficiaries are obviously our students of law. And we are very lucky that we have been able to organize this fantastic event jointly with the Department of Political Science and Sociology. So as we have heard that it is a very complex scenario the Myanmar is also now the Rohingya people are facing. So one of the greatest mass killing is going on. So we have also seen that the lacuna of the international law, despite all evidences are clear in social media and everything, we are just seeing everything. Every world knows what is happening, and unfortunately, the adequate media is not coming. So this is a lacuna of international law. There are a lot of issues like evidential problem. There are political issues. A lot of issues are making things much complex. But we don't want to see the same consequences as Bosnia-Herzegovina, that they could not get the adequate remedy. Even they put the matter in the International Court of Justice. So anyway, found that there are issues to be discussed, issues to be settled in international law, like ethnic cleansing. The argument is ethnic cleansing, but in international law, this issue is not clear. This issue is not defined. So the thing is coming like that. So if you expel them from your territory, and if you don't have ulterior intention to kill them, then it's not going to be genocide. This is simply a disaster. And if this law stands like this, then this unfortunate situation might again occur in Myanmar case. Anyway, so in this juncture, I would like to thank all the participants, especially on behalf of the Law Department, on behalf of the PSS Department of the North-South University, for all the students who have come here, and especially the honorable guest. And we are highly accomplished and honored that such an accomplished person is with us. So we want to give you special thanks to come here to manage time and to impart some knowledge with us. And thank you very much, and all the faculty members who are here. So I would like to give you thanks for joining here, and I'm sure that our students have learned a lot of ideas and thoughts, which will also give him impetus for further research and further work. So with that, I would like to close the speech, and thank you very much, and have a good day. Thank you.
Thank you. Thank you very much. We have some small refreshment in the faculty lounge, cookies and coffees. Please come and join there. I hope our guests will also come so you can get more informal interaction opportunity.